Good morning, everyone. I'm going to give folks a little more time to log on. So we'll be starting the webinar shortly. Okay, what do we think? We want to get started? Okay. Good morning, everyone. Good afternoon to you on the East Coast. Thank you for joining us today for a discussion about Brackeen v. Haaland, which was before the United States Supreme Court for oral argument on November 9th. This panel is sponsored by the American Bar Association section of Civil Rights and Social Justice. And we'll be sharing a recording of this program with everybody who's registered so that you can share it widely with your networks. Before we begin, we have some welcoming remarks from Deborah Enix-Ross. She's the president of the American Bar Association.
Hello, I'm Deborah Enix-Ross, president of the American Bar Association. It's my pleasure to welcome you to this final webinar from the ABA section of Civil Rights and Social Justice to conclude Native American Heritage Month. I thank the section and its members for their work to help mark this important celebration and for all the section does throughout the year to promote equity and justice. The contributions of Native Americans to our national fabric are profound and lasting, and the law is no exception. The ABA is proud of our affiliation with the National Native American Bar Association to help us exercise our national voice for the profession as we identify issues of concern and advocate for justice. The topic of today's webinar is of particular concern to the ABA, which filed an amicus brief with the U.S. Supreme Court in support of the constitutionality of the Indian Child Welfare Act, or ICWA. This act is intended to protect against the separation of Native American families. Our brief sets forth ABA policies supporting the rights of Native Americans and recognizing the constitutionality of the ICWA, which plays an important role in protecting children's and parents' legal rights to family integrity and due process. Our advocacy on these and many other issues of justice and the rule of law would not exist without our members' support. If you're an ABA member, I thank you. If you're not an ABA member, I encourage you to visit ambar.org/join and consider joining us. And here's another request. On social media like LinkedIn and through your professional connections, please spread the word to your colleagues, especially to the young lawyers and law students you know, about your experience with this webinar, what you have learned, and how your involvement in the ABA enhances your work and service. Thank you for all your continued outstanding work and dedication that makes our legal system strong and committed to equity and justice for all.
Thank you, Deborah. So we're hoping that today's webinar would be a discussion both between the panelists and with you, the attendees. So during today's program, we encourage you to ask questions of our panelists through the Q&A and not the chat function. There's going to be a couple of us who are going to be monitoring the Q&A, and we'll do our best to address questions, but probably at the end. We've got a lot of ground to cover today, so I'm going to dive right in. In a little bit, the panelists will be introducing themselves and talking about their role in the case, but very briefly, today we have Prudence Beidler Carr. She's the director of the ABA Center of Children in the Law. Erin Lynch, who is a staff attorney for the Native American Rights Fund, and Paul Spruhan, who's Assistant Attorney General in the Litigation Unit for the Navajo Nation Department of Justice. I'm Suzanne Garcia from the Tribal Law and Policy Institute, and I'll be your moderator today. You might hear me signaling to the panelists about how much time they have left, because we could easily spend hours discussing this case, and we want to leave time at the end for question and discussion like we talked about. First, we wanted to give some context before getting into the discussion. So right now I'm going to hand it off to Erin and Prudence to talk about the Indian Child Welfare Act, which is the main law under scrutiny in this case, and some other issues that we thought would provide some important background information. Erin is going to begin, and I think Prudence is going to join her.
Great, thank you so much. My name is Erin Lynch. I'm a senior staff attorney at the Native American Rights Fund. Thank you so much, Suzanne. It's a real honor to be here with you this morning. I'm in Anchorage, Alaska, and it's a beautiful sunrise right now, and it's -3, so a good crisp morning. So I am going to give just a basic, very quick overview of the Indian Child Welfare Act, and then the issues in this case, Haaland v. Brackeen. And then I will kick it over to Prudence and Paul, and we'll have a good discussion. So as I said, I'm a staff attorney at the Native American Rights Fund. We have been involved in all of the litigation defending ICWA in all of the 3 recent major federal challenges to the Indian Child Welfare Act. We have written the tribal amicus brief, along with our co-counsel at Denton's. One quick note about ICWA. ICWA was passed in 1978. It's a law that's over 40 years old. It has a lot of provisions to it, but broadly, ICWA is a set of minimum federal standards that apply to state child welfare proceedings that involve Native children who are either enrolled in a federally recognized tribe or who are eligible to be enrolled in a tribe and have a biological parent who is enrolled. So ICWA broadly says that whenever possible, children should be placed in familiar settings with close or extended family or within their tribal communities. And in the last 40 years since ICWA was passed, child welfare experts have really come to understand that this concept, which people refer to as kinship placement, where children are placed with their extended families or in their communities, is best practice. So that's why you'll often hear people say ICWA is the gold standard. This is why, is because it centers kinship placement, excuse me. One final note, I'll get to the amicus briefs here in a minute, but the research does show that all children, when they are connected to their family and their identity and their culture, that results in the most positive outcomes for them, right? So that's true of all children. It's especially true for Native children. And that's one of the reasons that Indian country and so many experts from across the child welfare and medical and legal spectrum have come in to support the Indian Child Welfare Act. So the federal courts don't really hear ICWA cases all that often. ICWA, or child welfare cases, I should say, are really live in tribal courts or in state courts. The United States Supreme Court has only heard 2 cases previously dealing with ICWA, and so the oral argument this last, earlier this month, was only the 3rd time that the court has really considered an ICWA case. You might remember the most recent case was a little less than a decade ago, the baby girl case. And in that case, in the majority opinion, there was a reference to the child's blood quantum. And I think when folks think of this case and sort of where did it start, a lot of people look at that opinion. And I say that because blood quantum has nothing to do with the Indian Child Welfare Act. As I said, children qualify for ICWA if they are members of a federally recognized tribe or eligible for membership. There's nothing in ICWA that relates to blood quantum. And so many people feel like that was kind of a signal by one of the justices for someone to look into ICWA or to start bringing cases challenging ICWA as being race-based. and not on membership. And again, when we talk about sort of broad concepts about ICWA, everyone for decades has considered it a law that is grounded in the political relationship between member children, citizen children, and their tribe, and the political relationship between federally recognized tribes and the United States government. There is no racial component to it. So as I mentioned, there have been 3 big federal court challenges to ICWA. The first was in the federal courts in Virginia, second was in the federal courts in Arizona, and then here now we have the Brackeen case, which has had a number of names since it was brought in the Northern District of Texas in October 2017. So in that complaint, or the amended complaint, I should say, the plaintiffs, who are the state of Texas, and then 3 non-native foster families, brought these sort of very large constitutional challenges to ICWA. They were pretty new and pretty expansive. So one would be, I'll just briefly talk about kind of the constitutional doctrines that are at play, and then we can get into the weeds in the discussion. So we have anti-commandeering, we have non-delegation, then there is an APA challenge. There's also a challenge based on the Indian Commerce Clause. And then finally, there's an equal protection challenge to ICWA. It's a lot to get your mind and arms around. I'll just say that, right? For anyone who has read the Fifth Circuit en banc opinion, that was 325 pages. It was a very fractured opinion. It's a little difficult to make your way through all of it because it's so unusual to have a law that's been on the books for over 40 years be challenged on so many big constitutional doctrines. Let me just pause for water here. So the federal district court in Texas basically found for the plaintiffs on all but one of their challenges. The case was then appealed to the Fifth Circuit. The Fifth Circuit panel overturned the district court and upheld the constitutionality of ICWA. However, there was a partial dissent related to commandeering. And so the plaintiffs sought en banc review. The full Fifth Circuit heard the case en banc, I think that was January 2020. So it was right before the pandemic. And the en banc opinion, as I said, is 325 pages. It's a lot to make your way through. We had to actually map out all of the judges, all of the issues in the case, and see where things came out. The takeaway from that opinion is that the Fifth Circuit en banc found that Congress did have the authority to enact ICWA, that ICWA does not discriminate on the basis of race. It upheld most of the provisions of ICWA as constitutional. There were a few provisions that were an 8-8 split, right? So what that does is it's precedent for the specific case, but not controlling precedent for other cases. There was a narrow majority that held that 3 provisions of ICWA unconstitutionally commandeered states. And then at the end, there was an opinion from Judge Costa that said, this is all an advisory opinion since state courts don't have to listen to us. So it's a bit all over the map. There were cert petitions that went in from all of the parties. I should back up and say that the plaintiffs, as I mentioned, are Texas and then 3 non-native foster families. On the side defending ICWA, we had the Department of Justice, and then we have some tribes that have intervened, 5 tribes, including Navajo Nation, and I'll kick it to Paul here in a bit to talk about his perspective. So cert was granted, and we then sort of went through another round of briefing. And if you are interested in reading any of the briefs from the beginning of the case in the district court on to now the merits briefs in front of the Supreme Court, all of those can be found on the Tribal Supreme Court Project website. The Tribal Supreme Court Project is a joint project between the Native American Rights Fund, where I work, and National Congress of American Indians. And any case that has anything to do with Indian law that is before the United States Supreme Court, all of the briefs can be found on the Tribal Supreme Court Project website. Before I kick it to Prudence, I wanted to just say a couple of things about some of the briefs that went in. the coalition of entities that came in to support ICWA, I would say, was really an avalanche from a wide variety of interests. So there were a number of briefs from governments. For example, there's a brief from the members of Congress, supporting ICWA, talking about how ICWA is well within Congress's authority. There was a brief from over 20 states who were writing from the perspective to sort of counter Texas's perspective, basically saying that they do not feel commandeered when it comes to ICWA, and that they have valuable relationships with tribal partners that they would like to maintain. There was also a brief, as I mentioned earlier, the tribal amicus brief. Almost 500 tribes signed on to that brief. And when you count the 5 tribes who are parties in the case, it's 502 tribes total have weighed in this case, which we think is the most tribes ever to be on a brief together before the United States Supreme Court. So there's overwhelming support for ICWA from Indian country. There's also a bunch of briefs that I really encourage people to read if you have specific questions about any of the legal doctrines that are at issue in this case, or if you'd like to learn more about ICWA. So if you'd like to learn more about the history of boarding schools or the federal and state relocation programs, you can find that in either the tribal amicus brief, or there's a brief from LA County, which is really interesting as well, that goes into some of that history. If you're interested in learning more about ICWA as the gold standard, I would suggest looking at the Casey Family Programs brief. Excuse me. Many of you might be familiar with this brief. A version of this brief has been filed at every stage in this case. And the Casey Family Programs brief really goes into the concept of kinship placement and looks at the research and talks about why it is, why kinship placement and ICWA are considered the gold standard. There are also a number of important briefs from legal scholars. So we have administrative law scholars, Indian law scholars, constitutional law scholars. There are some originalist arguments in this case, specifically the commandeering arguments that Texas has been advancing. And so there are some really interesting briefs from originalist professors and experts talking about originalism as it relates to Indian law and tying things back to treaties that predate the United States, right? If you really want to talk about foundational, primary, original documents. There's also a great brief from former foster youth. And I think that's something that had really been missing from the case before this round of briefing before the court, is the actual experiences of foster youth and how ICWA shaped their cases and really ended up shaping their lives. I will say the opposition, the folks who are fighting ICWA in their briefs, make a lot of statements asserting essentially that they know what's best for Indian children. And so I want to highlight that brief because I think it's very important that those former foster youth were able to tell their own stories and talk about what is best for them. I'm sure there are other briefs I'm forgetting. Oh, I should say there's, the ABA wrote an excellent brief as well. There are briefs from parents, attorneys, and from non-native foster parents themselves who are in support of ICWA. And if you're curious about how ICWA actually works in state court cases, I would highlight those briefs to look at. I think that was one thing that sort of became clear at oral argument is just because child welfare cases, as I mentioned, are usually in tribal courts or in state courts, the federal courts don't necessarily have a lot of familiarity with how those child welfare systems work. And so those briefs really kind of highlight the mechanics of the system and why ICWA not only protects Native children, but also really protects family autonomy and the rights of parents. There are several briefs I'm sure that I am missing that are excellent. Like I said, so I think in some of the materials, there's a link to the website on, you can either go to the Tribal Supreme Court Project website and there'll be a full list of the briefs. There should be another link in the materials to a page on NARFs, website, where we have listed all of the briefs that came in support of ICWA, all of the amicus briefs, I should say. And then we gave a little synopsis of each of them. So if you are interested in one of the legal issues in the case, you can go to that list and find all of the briefs that deal with that specific issue. There are over 20 briefs, so it's a little much to navigate. So we wanted to put that together just to help people make their way through all of it. But I have been encouraging advocates to look at those briefs and to use them in current cases that you might have, because there's really a wealth of information. One last thing that I completely forgot to say is the briefs from all of the medical experts. So the American Academy of Pediatrics and the American Medical Association also put in a brief in support of ICWA, talking about why it results in better outcomes for Native children. And again, tying it back to this concept of kinship placement and why that's best for all children. So there's a lot to go into. I don't want to take up too much of the time. And again, I want this to be more of a conversation. We can talk more about going into the specifics of the legal doctrines, but I'll go ahead and pause there.
Terrific. Thank you so much, Erin, for all of the background and for referencing all of the different, all of the different participants in the amicus briefing. I wanted, actually, that's a really nice transition for me to just highlight how honored I am to be here today, recognizing all of the really significant viewpoints that came in an effort to value and to rally around the importance of this federal law, which has been in practice in the state courts for 43 years. And I want to highlight on behalf of the ABA how significant it was for the American Bar Association to have an opportunity to weigh in and without any hesitation to weigh in very much on the side of arguing that ICWA is constitutional, always has been constitutional, and is actually needs to be implemented even more aggressively than it currently is. But I would be remiss if I didn't highlight, in addition to being really honored to be here with these panelists, it was a great privilege to work with Caroline Mayhew, who's on the Zoom today, and the law firm Hobbs Strauss, who led the ABA amicus brief, along with a number of very active ABA partners and members. And so it was just a really great opportunity to be able to participate. And the two main reasons that the ABA got involved are, number one, because of how significant this case is for recognizing tribal sovereignty and the political status of tribes, and that membership in tribes and classification as an Indian child is not a race-based classification, and obviously has lots of implications if that were to be ruled on in a different way. And sort of on long-standing ABA policy in support of tribal sovereignty and political classification, it was really important for the ABA as a professional association of legal professionals to weigh in. And then also, and this is more of the reason why I'm here today, I think, the second reason is because this case has really, really significant implications for child welfare law. I'm not sure that the state of Texas or even the Brackeens and the other plaintiffs understood quite the breadth of what they were arguing in the early stages of this case, but some of the arguments that have been made have extraordinary potential to impact the structure and implementation of federal and state child welfare law across the country. And getting to work here at the ABA as the director of the Center on Children in the Law, it was really important for us to have an opportunity to weigh in and frame some of those issues for this court, which, much like, as Erin pointed out, ICWA is a statute that is implemented in state court proceedings, so isn't as regularly not something that we see legally challenged in federal courts. With child welfare law, which is the primary area of implementation of ICWA, that's also in state court. And so very rarely does the Supreme Court weigh in on anything related to child welfare. And so when they do, there's always a bit of a risk that some of the language that comes out in these decisions has large implications. The other thing that I wanted to say as background, which is related to that child welfare context, is, and hopefully of the 345 participants we have on right now, many of you are familiar with child welfare law. But we in the field have had a really significant focus for a long time, but with renewed energy in recent years on the importance of lived expertise and on shaping laws based on the leadership and perspective of those who have been affected by these areas before. So what does that mean? In the child welfare space, it means making sure that laws that are implemented in this field are designed and led in the design and implementation by individuals who have lived experience, either as parents who have experienced the child welfare system, as children who have experienced foster care, as kin who have been kin caregivers, or have, in the case of some of the history of ICWA, experienced removal of children from their families and communities. And in the case of tribes, leadership from tribes themselves. And I think that recognition of how important it is that all the laws in our field be led by those with lived experience is particularly important when talking about ICWA, because Erin highlighted that ICWA is the gold standard in terms of what's best for children. And the reason that it's the gold standard is because it is also the gold standard of human-centered design. ICWA was designed, it is the only child welfare law that we really have in existence that was designed with lived expertise. 43 years ago, this law, after 4 years of testimony before Congress, was created at the urging of individuals who had been removed from their families as children, at the urging of parents who had suffered the experience of loss when their children had been removed, at the urging of grandparents and extended family members who had experienced the loss of children being removed from their families, and at the urging of tribes. This is a lived expertise law that has been on the books for 43 years, representing the gold standard of child welfare practice because it comes from lived expertise. And I think that's a really important grounding when we're talking about what's under review before the Supreme Court, because it really raises questions about why this law in particular is being challenged when it is, as Erin pointed out, so representational of what's best for children and comes from the direct experience of children. The last point I'll make on that is that I have kids of my own, and when I was explaining this case before getting to go to the court a couple weeks ago, I had them listen to the NPR 7 minutes, but then I sort of walked them through a couple of experiences from the foster youth brief that Erin described, and the former foster youth brief. And my kids, even, as young as they are, when I was leaving to go to the court, my son, who's 10, said, just make sure that they're listening to the kids. Just make sure that what they're listening to is to the kids who want to be with their families. And so I think that's a really important message, even when we talk about sort of all the different legal frameworks here, that sort of origin and touchstone of what this case is about is really significant and important. So I will pass it to you, Paul. Or Suzanne, sorry if there's a transition point.
Yeah, thank you, Prudence, and thank you for bringing it back to the families and the kids, because that's what's really at the heart of this. There's a lot of other arguments that have been thrown in there and a lot of other issues that have been brought up, but what we're talking about is families here. And it's always helpful to ground it back at that. I think what we were going to, so for the attendees, we're monitoring the questions, but we're going to do them at the end. And we're also, I'm seeing in the chat, there's some resources that are being put in there as the panelists speak. So, and like I said, all of this is going to be recorded, and I think you'll have access to those resources afterwards. Next, what we were going to do, so we've had a chance to speak. The panelists are going to introduce themselves a little more in depth and talk about their role in the case. And I think I'm going to toss it to Paul first because he's the panelist we haven't heard from yet.
All right. Hello. Can you all hear me? Yes.
Yeah.
All right. Thank you very much for the opportunity. The Nomination Department of Justice has been involved with this case from the beginning about 5 years ago. I think this is the only third time that I've publicly discussed this case, that the nomination has publicly discussed this case outside of the nomination. So thankful for this opportunity from the ABA to give some remarks. It's interesting looking at the list of attendees. I recognize a number of names, and I notice we have some current and retired Navajo Nation judges, as well as some other well-known Navajo attorneys. So I'd like to say yate to all of the Dene out there who are listening in. The Navajo Nation is a party to this case, and we are a co-party as the tribal interveners with a group of 4 other tribes who are represented separately: Cherokee, Oneida, Morongo, and Quinault. And we were involved in this situation before this case even existed. Haaland versus Brackeen, as I believe Erin mentioned, the Brackeens are the family at the center of this case, who successfully adopted one Navajo child, Navajo Cherokee child, and is currently in the Texas state system fighting the Navajo Nation in an attempt to adopt the half-sibling of that same Navajo child, who also herself is separately enrolled as a Navajo tribal member. So we were involved in the Texas family court system, district court system with the Brackeens before this case. We will presumably be involved with the Brackeens after this case, which is to say this case is very personal. It's very direct. It directly implicates the Navajo Nation's interests and the interests of these children. I think it's important that other people have mentioned this is ultimately about the children. And one of the advantages we have, by the way, I am in Window Rock, Arizona, the capital of the Navajo Nation, in what we refer semi-facetiously as the infamous utility room, which is my office, which literally does have a sign on the door that says utility room to chase off the bug people, et cetera, when they come to exterminate in our particular office. So, we tried to intervene in the district court case, but first to attempt to kill it, what we call the Rule 19 bomb for those federal rules of civil procedure wonks, if any. Rule 19, of course, is discussing indispensable parties, meaning that the case was Brackeen et al. In the state of Texas, Indiana, Louisiana, versus the Department of Interior. And Haaland, of course, is the named defendant as the Secretary of the Interior, Deborah Haaland. And so the nation and the Cherokee Nation, et cetera, are not automatically parties. The plaintiffs get to decide who the defendants in the case are, and the tribes were not, because it was packaged as a direct challenge to federal authority in ICWA. Mind you, as was discussed in the oral argument and in many, many briefings through this whole process, the only people who actually decide these questions were not made defendants in the federal court, which is to say the actual state judges. And therefore, there was some limited discussion in the Supreme Court oral argument. Justice Gorsuch particularly, wait a minute, why is there even standing? I don't know, you don't know, something. Anyway, let's talk about the merits of the case. However, it's important to note there were challenges to ICWA by the Brackeens in the state system that went all the way up to the Texas Supreme Court parallel to this federal proceeding. The Texas Supreme Court was uninterested for whatever reason it was, and therefore it is now back in the Texas District Court. One of the interesting aspects of the case is there are facts and there are facts. There are facts involving ALM and YRJ, the 2 Navajo children involved, which have been relevant and not relevant. Ian Gershengorn, the attorney for gender, noted that really there's no real record here because it's a facial challenge. However, this involves 2 very specific Navajo children who are involved in a situation not of their own making. And I think it's very important, as has been noted, to take this sort of sound and fury and grand constitutional concepts, but also understand that there are families and particular individuals involved in this case. So we were successful as interveners finally at the Fifth Circuit level because our Rule 19, actually our intervention motion was denied to prevent consideration of the Rule 19 motion to dismiss for failure to join an indispensable party. We elected not to appeal. We waited around to see what the judge was going to do. The judge completely slashed and burned ICWA down to the ground, but in doing so noted, there was a reference to blood quantum in the chat that, oh, well, isn't it interesting that many tribes, including, I don't know, I'll just pick a random tribe from a miscited section of the Navajo Code by our friends at the Coldwater Institute, that the Navajo Nation uses blood quantum, partially, as its enrollment criteria. We didn't particularly care for that. So we decided, well, maybe we should intervene as a party. This was after, of course, the decision was already rendered and several other parties had appealed. And therefore, we then had to go to the Fifth Circuit and became an actual party in the case. As Rebecca Nagel kindly included in her This Land podcast, I personally had 5 whole minutes to argue before the 16-judge en banc proceeding. So I actually argued part of this case as a party. Wasn't fun, it was interesting, not fun, seeing 16 different people staring at you and then everybody else in the background staring at your bald head. But we have been directly involved in the case and continue to have done so. We filed jointly with Cherokee et al. In the merits stage, but we did file a brief in opposition ourselves, which I would submit to you if you look at the briefs and are interested in what the Navajo Nation's specific point of view is on the case, that you look at our brief in opposition to the 2 cert petitions filed by the Brackeens in Texas, because that will give you the most clear vision of the Navajo point of view on this case, given that the 2 children at the center of this case are in fact Navajo relatives. And as will be noted as we go through, there is a continued dispute with the Brackeens in Texas court, no matter what the Supreme Court does in this particular case in terms of certain parts or all of ICWA being struck down or not. We will continue to be involved seeking a family placement, a maternal great aunt, a clan member of these children to place YRJ with that family on reservation. And that's what I have to say. Thank you.
All right. Prudence, do you want to talk about your role in the case?
Sure, and I can be fairly brief on that. You know, I think unlike Paul, who had been involved from from its inception, the ABA was only involved at the Supreme Court level. So we filed an amicus brief. The ABA has an amicus committee, which, fun fact, Justice Ginsburg used to be the chair of the ABA amicus committee many, many decades ago. But the ABA has an amicus committee and reviews and makes decisions about when to file a brief in coordination with counsel, in this case, Hobbs Strauss. And so my role, although we filed a brief that challenged the equal protection arguments, as well as the Article 1 challenges and the anti-commandeering, a lot of the focus from the sections that I worked on was the child welfare components. And the sort of 2 that I'll highlight, because I think that they were the ones that we maybe put forward in ways that were particularly important for the child welfare legal space. One is that Texas, as a plaintiff, did attempt initially an argument saying that this area of law is not covered by Congress's plenary authorities because all child custody law is exclusively the jurisdiction of state law. And so that's an example where, right, like if we had a Supreme Court that ruled that, that would essentially invalidate all of the entire structure of child welfare law dating back to 1961, and really remove the entire concept that child welfare is something that is governed simultaneously by federal and state law, and would call into question every child welfare statute that's been passed by Congress, since ICWA and before ICWA. And so that argument of sort of saying that this is exclusively, that anything related to child custody is exclusively state law, and therefore it was inappropriate for Congress to enact ICWA, was one of the key arguments that we sort of challenged. And then a second area that we really focused on was this idea of discrimination. So in the equal protection context, there are really 2 claims. One is that the children who are covered by ICWA are being discriminated against. And so it was an argument sort of made on behalf of children that claimed that by being covered under ICWA, they are experiencing a less fair legal system. And we did feel it was incredibly important to weigh in on that and highlight not only, as Erin pointed out, the sort of gold standard aspect of ICWA, but to really ground that even more deeply in the fundamental liberty interests, which the Supreme Court has recognized in the past, that all of us have to our families, right? And so parents under Supreme Court precedent do have long recognized fundamental liberty interests in raising their children. And that's what's at stake here. And children have fundamental liberty interests in being raised by their parents. And so we really wanted to highlight that sort of this isn't something where you can just sort of weigh in and say, you know, externally. I think one thing that was very telling for us in trying to frame that argument was the Goldwater amicus brief, which Paul referenced already. If you read it, it's very jarring, the language quite in contrast with the lived experience briefs that Erin was mentioning. The Goldwater brief, for example, as amicus, refers repeatedly to these children, and it's very othering about sort of writing and advocating on behalf of individuals with whom they did not have a connection, and it's really jarring to read that. And so we, from the ABA side, really felt it was important to ground for the Supreme Court's evaluation of this law and evaluation of the equal protection arguments, to ground that in a recognition and understanding that what they're really looking at are constitutional liberty interests in family. So those are sort of two of the frames that I'll share.
Thanks, Prudence. Erin, what you obviously played a big role.
Oh yeah, well, no, I mean, you know, and the Native American Rights Fund was involved in a couple of different ways. So first, as I mentioned, NARF, along with our partners at NCAI, run the Tribal Supreme Court Project. And so not only is that a home on the internet for all of the briefs and materials related to any Supreme Court case that is where an Indian law issue is at play. But the Tribal Supreme Court Project also, for any Indian law case that where cert is accepted by the court, if the parties, the tribal party or parties, you know, agree and are up for it, the Tribal Supreme Court Project initiates and then runs a work group focused on the case and the potential amicus briefs that will go in on the case. And so the point of this is just to make sure really that everyone who's submitting an amicus brief on the pro-tribal side is coordinating, right? Because we know that the more, or we have heard that the more amicus briefs that are filed before the court, the fewer get read, right? And so we want to avoid briefs that kind of just say, yeah, me also, right? I agree with that. So we want to make sure that all of the briefs are presenting unique perspectives and unique arguments, and that they all fit together kind of like a puzzle, right? And are supportive of each other and don't contradict each other. And so my colleagues at the Native American Rights Fund, mainly in the DC office, take the lead on that project and really did a ton of work coordinating the briefs. And I don't mean to say coordinating as if they were writing them, because they weren't, but it's mainly just a lot of sharing of drafts and conversation among any attorney in the Indian law world who wants to participate. And there were definitely briefs too, I should mention, where the parties did not participate in the Tribal Supreme Court Project website or project, like the briefs filed by the states. They don't, the state attorneys general do not, you know, share their briefs outside of their group ahead of time. So that was one way in which NARF was involved. And then, as I said, I and several of my colleagues and our co-counsel at Denton's wrote the tribal amicus brief, which was filed on behalf of, I think it was our final number was 497 tribes who all signed on individually, and 62 Native and tribal organizations nationwide and regional. And that tribal amicus brief, you know, I touched on it a little bit earlier, but to kind of build on what Prudence and Paul were saying, it, you know, really kind of talks about the history for why ICWA and grounds ICWA in that lived experience with state child welfare systems. Prudence also talked about the potential impacts to the child welfare sphere. So the tribal amicus brief also tried to discuss the potential impacts to tribes and to the entire field of federal Indian law if the court goes along with some of the arguments that the petitioners have been advancing. And just briefly, I would note that, you know, in previous rounds of briefing in this case, Texas and the Brackeens really left it to their amici to make some of the most extreme outer limits arguments. But when it came time for the merits briefing in the Supreme Court, they, you know, I think a few of us were sort of saying they took a very YOLO approach, right? Like they kind of put it all in there, and a lot of their arguments, like I said, would be exceptionally damaging. So they are encouraging the court to completely revise its understanding of the Indian Commerce Clause, which is foundational to federal Indian law. It's foundational to constitutional understanding of the United States relationship with tribes. They are also encouraging the court, as we've referenced before, to adopt this equal protection line of argument that they've been advancing, recharacterizing ICWA not as a political law, right? As we started the conversation with, as a law that's grounded in the political relationship between tribal citizens and their tribal government, and the tribal government and the federal government, but recharacterizing that as a racial law. And you know, if the court does sort of follow that line of argument, it would, I think, as many people have said, really undermine pretty much all of federal Indian law. Federal Indian law is found in Title 25 of the U.S. Code, and it's hard to go through the U.S. Code and to find a law that would not be impacted. Some of the plaintiffs' arguments, so the tribal amicus brief really tried to focus also on explaining how you know, the plaintiff's arguments would undermine tribes. And if you're interested in reading about some of those other laws that would be affected, you can look at the tribal amicus brief, or also the members of Congress brief has some pretty good sections on that as well. The last thing I'll say about the tribal amicus brief is we really tried to highlight that none of the plaintiffs' arguments are, well, if you know, if you go by current precedent, I'll say that the plaintiffs win on nothing, right? The law is squarely behind ICWA on all of the arguments that they've advanced. Some of their arguments, when you read their briefs, might seem sort of narrowly tailored or not as outer limits as some of the other arguments, but I am always trying to reinforce to people that they're actually all pretty outer limits, because there is no legal foundation for any of them. And an example of that is in the equal protection sections of their brief, they will talk about this case Mancari and whether, and they're reading into it a limitation of Congress's ability to make laws for folks who are on or near reservations. And I wanted to flag that, and we you know, talked about it in the tribal amicus brief too. I think for some people who aren't as familiar with Indian country, you might think on or near, okay, that seems like sort of a tidy way to think about things, and it's actually not. Even something that seems limited, like an on or near holding, would have disastrous impacts for tribes. For example, there are 229 tribes in Alaska. 228 of them do not have reservations, right? So you're immediately removing from this analysis and from ICWA the 228 tribes in Alaska who don't have reservations. There are also tribes in California, in Montana, in Virginia, and other places that do not have tribal lands. There are many tribes in the lower 48 that have tribal lands that are too small, right, for their tribal citizens to live on or near. So you would be removing the protections of ICWA from those folks as well. When then you're also talking about the many, many millions of Alaska Natives and American Indians who are tribal citizens, but they do not live on or near their reservation, right? And the tribal amicus brief, and as I mentioned, the LA County brief talk about this quite a bit with the federal government, and then later with the state government's relocation plan in the 50s and 60s that really encouraged folks to move away from their tribal communities. And so on or near, like I said, might seem like a nice, you know, sort of tidy way to think about things, but the impact of an on or near finding that, you know, or in a revision of the Mancari case would literally affect hundreds of tribes and millions of tribal citizens. And so, you know, that those were sort of the focuses of the tribal amicus brief. And like I said, they sort of fit in nicely with some of the pieces from the members of Congress brief, with the LA County brief. You know, the last thing I'll say too, to reference Goldwater and what Paul and Prudence had said, is that, you know, the opponents in this case really, for years and through the entire history of this case, but going back to the case in Arizona, which was brought by Goldwater, and the case in Virginia before that, they have really trafficked in, just to say it, racist stereotypes of Native people and Native lands. And you will see threads of arguments in their briefs that imply that they are the protectors of Indian children, that they know what's best for Indian children, and that tribes do not, or that tribes have some other, you know, sort of nefarious interest. And so the tribal amicus brief also spent some real estate talking about how central and sacred tribal children are to tribes, and how language affirming that is in many tribal constitutions and codes, and how it's really a pole star and you know, sort of a guiding concept for tribal governments, who many of whom are running their own independent child welfare programs and tribal courts, where they take jurisdiction of and protect Native children and work with families towards reunification. So, you know, if you're interested in, I guess, in any of those concepts, I would check out the tribal amicus brief, as well as some of the others that I mentioned.
Definitely a lot to dig into there. All right, so now we're going to move on to a discussion about the oral arguments. So I was listening to it, but my understanding is you all were there. This is your time to reflect on those oral arguments, and I guess what your takeaways were, or what struck you the most. And I think I'll start with Paul again.
Okay, thank you. We were all there. You know, I read the transcript yesterday and today. I would not recommend it. No, I'm just kidding. It's 227 pages of question, answer. It's kind of interesting what the court reporter includes and doesn't include in terms of trying to give you a sense of how each speaker sort of address the court, but there's no, even if you listen to the recording or the audio, which I've done in other cases, there's no substitute for being there to see the dynamic of the justices with each other, to see their dynamic with the attorneys. Because one of the things you would not have known if you just listened to the audio or read the transcript, Alito was like this the entire time when the Brackeen's attorney, Mr. McGill, spoke, and then Solicitor General Stone from Texas. And then when Ed Needler from the Solicitor General, all of a sudden, like the chair physically perked up, and then he was ready to go. One of the other interesting sort of trivia is Justice Thomas disappeared for a certain period of time during the argument and sort of swatted the curtain and kind of, you know, and then came back. And you would have known that by the audio or by the transcript itself. And so, you know, waiting in line is always a big deal. Seeing what's going on after the argument is a big deal. But just to throw it out there to get discussion going, it's interesting. This discussion of blood quantum was almost never discussed, even by Mr. McGill on behalf of the Brackeens, even though that had been such an important part of their advocacy up till that point. And just to answer the question at the very beginning, blood quantum is one way that tribes define citizenship, that is to say membership. And so ICWA on its surface says an Indian child is someone who's an enrolled tribal member, minor, or is eligible for enrollment and one of their parents is a biological child of a tribal member. And so the question is, well, okay, why is blood quantum even relevant? As Erin mentioned, Paul Clement, you may have heard of him, prominent Supreme Court advocate for the GAL for in the baby girl case, made it a big deal. 3-256 was the mantra picked up by Alito in that opinion. And so throughout the discussion, my 5 minutes was dominated in the Fifth Circuit by a discussion of how the Navajo Nation defines citizenship, which is under current Navajo Nation law and the Navajo Nation Code, 1/4 plus you can't be enrolled in another tribe, plus a parent has to be enrolled. And so the question becomes, does it really matter? Does it really matter? And we fought this throughout the entire process up until we decided collectively with the other tribes, why do we have to do that? The answer is we don't. We don't have to defend any individual tribe's enrollment criteria because 1, it's a facial challenge. 2, that's not even what ICWA says. There's no reference whatsoever to Indian blood anywhere on the face of the statute. And so that was interesting because I would have expected Mr. McGill to hammer on that point. One of the other sort of observations, and I'll throw it to the other two, is, and I'm reading the transcript back today in preparation for this thing was quite interesting because you see some of the seams and threads of the argument. And one of the things that became apparent, even by the United States, people kept conflating the Article 1 issue as to whether or not Congress has the authority to pass the statute anyway. Is it commerce? We never said that it was only commerce. Oh, look over there. The sort of bob and weave of McGill with Gorsuch trying to figure out how he was going to say something and he was going to stick to it. Right. But the idea that there's the Article 1 issue, plenary power, what does it mean? And then there's the equal protection issue. But even the Solicitor General's office conflated the two and made the argument that in fact they were the same standard. If you read the transcript, which live, you're going, it's 2 hours, you're like, oh God, can I go to the bathroom? No, okay, I'm going to listen to however long this goes on. You don't get that nuance. But when you read the transcript, that was a major part of what seemed to be confusing to people, the justices, whether intentionally or not, or theatrically, or, oh, I'm shocked that I would be so confused. And that's why I think it was important for Ian Gershengorn from the tribes to clean all of that up and to be the last person. And he got lucky in the draw because he was able to listen to everybody else and then say, okay, boom, 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 boom. This is it. This is Article 1. This is equal protection. They're different. Here's what the standard is. Because for 2.5 hours, you wouldn't even know necessarily, if you didn't know the context of the case, that Article 1 equal protection were different, that have completely different arguments and complete different standards. So that's one of the things that surprised me during the discussion, was either intentional or not, people slipped into arguing the same thing for both of these concepts, when in fact, importantly, they were quite distinct. And hand it over to Prudence or Erin as the moderator sees fit to have their comment. Thank
Who wants to go?
I'm happy to jump in and then pass the bulk to Erin. I will share. Thank you, Paul, for all of that. I agree completely that the experience of being there is very different. It was a very long hearing. Also, I've never been to an argument that's 3 hours. And so I think for Justice Thomas and others, there may have been some bio break needs that were visible and not on audio. I have to give huge kudos to Paul for rereading the transcript in advance of today. I will own very candidly, I did not do that, but I did try to look at my notes from it. One of the other just sort of interesting observational things was the degree to which Justice Gorsuch was whispering a lot with Justice Sotomayor and then also with Justice Barrett during different portions of the argument. And I think some of the questions that all three of them asked were intentionally complimentary, maybe taking it a stretch too far, but intentionally sort of lining up in the way that they were asked. The main thing for me that was really important, and I'll try to tie this actually to two of the comments that just came into the chat that came up a lot from Justice Jackson, was this question of legislative intent. And I think this actually goes very much to Dobbs. And so I know that the question in the chat was about, isn't this a Dobbs issue potentially by going back to the states? But actually, I think I see this case as a very different Dobbs issue. And we did, at the very last line of the ABA amicus brief, we did actually go so far as to cite Dobbs because there was a line in Dobbs that cautioned against court actions that wrongly remove an issue from the people and the democratic process. And the way that Alito wrote Dobbs was very much a separation of powers decision, saying that there are certain decisions that should be left to the legislature and to Congress and state legislatures. And in this instance, I think it's very difficult to square Dobbs with a challenge to a constitutional challenge to a law that was passed by Congress as a separate power from the judiciary, with full, acknowledged legislative intent for why it was passed. It has been implemented, as Gorsuch repeatedly noted, for 43 years by state courts. And as Jackson was asking kind of repeatedly, how is it possible? Why is this case even before the court, right? Like, why would it be appropriate for the court when it really, a lot of the arguments were very political about, is this law the best way to protect kids? Is this law the right policy? Those are absolutely policy questions. They are not constitutional law questions. And I think that to me was a really powerful framing, because it gets at this sort of overarching question of, why was it appropriate to challenge the constitutional basis of a law that's 43 years old and has been implemented across the country with no difficulty for this much time? That's a pretty unprecedented thing. And I would go so far as to say, I think part of the reason is that it's been used as a vehicle to challenge, as Erin was saying, a lot more of tribal law. And I think child welfare is sometimes brought in to sort of be used as a subjective vehicle for challenges to larger issues in sort of a separation of powers frame. So the main thing for me was a takeaway about how important it was to keep going back to this sort of separation of powers framework, that really this case probably shouldn't have been before the court at all. It was appropriately a statute decided by Congress.
Erin.
Yeah, and I will just a couple things to build on that, because I agree with Paul and Prudence, and to pick up on what Prudence just said. I think a lot of people are really thinking of this case, and sort of the framing is that if the court does go along with any of the petitioner's arguments, it really is actually a pretty enormous power grab by the court, right? They have a lot of federal Indian law precedent where they have noted or where they have referenced the Indian Commerce Clause, any number of other constitutional doctrines that were at play in this case. They would really have to walk away from a fair amount of their own precedent. And then, as Prudence noted, Congress clearly spoke on this issue. And so, for the court to say, oh, well, we don't want to take power from the people, we want, Congress to express a preference. Here, Congress did express a preference, and there is a pretty extensive legislative history for ICWA. It's actually all on the National Indian Law Library's website. If you just Google NILL, N-I-L-L, ICWA legislative history, it's all there. It's all digitized and Control F searchable. And Congress has spoken. And so for the court now to kind of go down these sort of paths that the plaintiffs are encouraging them to do so, it in a way, like ideologically, would even conflict with their recent decision, very, very recent decisions. The other thing I would note, and we knew this sort of, before going in, but to the courtroom, but, Indian law cases don't often, or don't always, I should say, break down on the ideological lines that other court decisions do from the Supreme Court. So for example, in Baby Girl, Justice Scalia was on the side of ICWA because for him, and to reference some of the things that Prudence said, this is really a family rights and sort of parents' rights issue. And Justice Gorsuch has a very strong foundation in federal Indian law. And you could really see that through his questioning, especially of Matt McGill, who is the Brackeen's attorney. And so for me, that was, I guess, affirming or something, but to really see Justice Gorsuch, get into it with Mr. McGill about the potential impacts to other pieces of federal Indian law, very foundational pieces of federal Indian law that deal with healthcare and other services and programs that millions of people rely on. And so sort of bracket that on one side. And the three of us, when we sort of chatted recently, we're kind of talking about this one other concept that I wanted to mention, which is coming out of the court. I definitely felt, I wouldn't say I felt good about oral argument necessarily, but and you hate to even sort of guess, I guess about where things might go. But it seemed through some of the questioning that there wasn't or might not be a huge appetite that the court has to really, for example, completely revisit the Indian Commerce Clause, right? But then talking to folks who listened to it, I want to acknowledge there was a lot of frustration and pain and anger and surprise at hearing some of the justices, I think it was Justice Alito, talk about how, well, he's talking about the third placement preference in ICWA, right, for other Indian families. And the point he was trying to make was that, tribes aren't fungible because, and he said something like, before the United States existed, tribes were warring with each other. He just kind of said this as a statement of fact. Which again, I think that kind of goes back to how the petitioners in this case, again, are sort of always dropping these breadcrumbs or dog whistles, whatever you want to call them, about tribes and Native people. And I think that was very upsetting to hear that language and to hear language from Matt McGill talking about tribes as, I don't know, maybe implying that they're governments that aren't trustworthy or governments that don't have the best interests of their citizen children at heart. I think that was really hard for people to listen to. And I wanted to acknowledge that. And I do think that for folks who have been involved in this case, we've maybe become a little, not desensitized to it, but we just sort of expect it from Matt McGill. And so, what's that famous debate, the Kennedy-Nixon debate or whatever, where, the folks who listened to it on the radio had different perspectives than the folks who saw it in person. I think there's some really interesting things to tease out there when you're just listening to the language, versus then also getting to see, as Paul was mentioning, the interactions between the justices.
Well, I'll throw a final in there, Erin, on that note, because, and I'll take it back to my 10-year-old who did ask me the morning of how many Native American Supreme Court justices we've ever had. And so as much as, there is diversity on our bench, realizing that this case that challenges so many fundamental, dating back to even before the founding of this country, so many fundamental structures around tribal law and Indian law and tribal sovereignty. And to hear that question, and it wasn't something I had thought, right? It was coming from a child's point of view. And it was a really big moment for me to hear that. And then to go into that courtroom and to think like, gee, that doesn't make sense.
Paul, did you want to weigh in again at all, or?
No, I think everybody said what was said, so happy to continue.
Okay. So now we're going to turn to, I think, questions from the attendees. So we touched on, I want to touch on blood quantum again real quick. Just, Paul, thank you for dropping the articles you wrote into the chat. But just a point of clarification, this was not something that, my understanding is blood quantum was not something that was a creation of the tribes themselves. That was not a concept that came from tribal nations, correct?
Correct.
Yeah.
If you want 50 long, detailed pages of why that's true, feel free to read the article that I put in there. I mean, it was interesting to be in the position of arguing this case for the Navajo Nation, having done all of that research previously on the history of blood quantum. So yeah, and to be asked directly by one of the 16 judges in New Orleans about this as if this was the central part of the case. And I think this, just to editorialize for 5 seconds, is the sort of elephant in the room, or so it seemed up until the oral argument, where it seemed to have dropped into the background. Now, again, if you read the transcript, I think there are hidden areas where it seems certain justices have already made up their mind that this is a racial statute, no matter what we say, right? And so perhaps in a majority or concurring opinion, this issue of blood quantum will come up again. But yes, you are correct that it is not a original or traditional or historic approach, but it is the one that and of course, one of the interesting discussions in the case was, how many tribes? How many tribes? As another of the 16 judges asked. I'm like, I don't know. No one's ever done it. But anyway, who cares? Look over there, you know. And so whether blood quantum, despite our best efforts, will sort of, reconstitute itself as to be a major portion of a majority concurring or dissent remains to be seen.
We also had a question about the commandeering arguments. Who wants to take that one on?
Yeah, sure. Well, I'll how about very briefly? Sure. The commandeering arguments, it's basically this concept that that there are certain areas where Congress can't tell states what to do, right? That these are areas where that have traditionally been left to the states, and that Congress isn't allowed to tell states what to do. Instead, what Congress can do is tie things to the spending clause, right? So Congress can say to states, hey, we'd really like you to do this thing. What's the classic example? Is it speed limits, right? Or seatbelts, right? Like we've got some federal highway money for you here. If you'd like that, you just have to, put these other things into your state law, right? And abide by them. So Congress can, provide money to states for certain things, and the states can decide whether or not they want to take that money and those obligations or not. So here, the state of Texas primarily has argued that it's a commandeering, that ICWA impermissibly commandeers state agencies and state courts to carry out these child welfare protections. And the core of Texas's argument is, as Prudence was saying earlier, that child welfare has traditionally been left to the states, and so Congress really shouldn't be butting in. If you listen to the oral argument or you were there, Justice Jackson, I thought, just had some devastating questions about commandeering. One of the, I had heard, was as we were leading up to oral argument, the term began October 1, and there were several oral arguments before Brackeen, obviously, and I had heard or seen snippets in the news that Justice Jackson was a pretty amazing questioner, but to see that in person, I think, was really something. Stuff of nightmares, honestly, to find yourself as a lawyer, being questioned by her when she disagrees with you, because she was so thorough and just so on point, especially on the commandeering questions, and even asked, I think it was Solicitor General Stone, for a commandeering case to cite that was earlier than 1992, which was essentially a way for her to point out that this concept, this constitutional doctrine of anti-commandeering, is pretty new, and some might argue made up, in the last couple of decades. So she also, though I thought had, she and others had some very excellent points about commandeering, and Prudence and Paul and anyone else, help me out if I'm mischaracterizing or misremembering this, but she was essentially saying, okay, sort of before the Constitution, the federal government said it would sort of deal with tribes, and then states individually were dealing with tribes. And it was not working out well, right? There was all this conflict between the feds and the states. And so in the Constitution, the federal government reserved for itself the ability and the power to deal directly with tribal governments, sovereign to sovereign, right? And so her line of questioning kind of spun this out. It's like, well, how could this be commandeering of state agencies when Congress heard about this incredible issue of child removal from tribal communities and tribal families, and it acted well within its constitutional powers to protect Indian children and tribes? How could that possibly be commandeering of a state agency when you, a state, don't even have the power under the Constitution to do that, right? And I think that sort of went to the heart of it, because Texas kept talking about state child welfare, this or that, and and they were not, intentionally characterizing this case as one or as ICWA as a law in which Congress passed to address specific issues with Native families and in furtherance of its trust responsibility, really. And so just her way of kind of taking even the framing, the petitioner's framing, and sort of spinning it and putting them on the spot, I thought was really amazing. It takes a lot of skill, I would say, right, to kind of get to the heart of the matter. And I thought she was incredible. But I'll pause there and kick it to Prudence and Paul if they have any other thoughts on commandeering.
The only thing I'll add is that I think Texas made a very strange opening statement in their argument, because Solicitor General Stone, the very first lines of the argument were about how much money the state of Texas receives from the federal government to implement federal child welfare law. And their standing is based on his assertion that if they didn't implement ICWA, they wouldn't get all of that money, which I think goes to Erin's beginning point, which is that it's not commandeering if you're getting money to implement federal law. So it seemed like he was sort of mooting out his own commandeering argument by talking about how much money is at stake because it's connected to the implementation of ICWA. That to me, that was just a really interesting, risky position to take.
Just some minor observations. Again, much like blood quantum, I would have expected in a 3+ hour argument, there would have been a lot more about commandeering. And I don't know what that means, right? Because of course, there's some discussion in the chat of, predictions. It's hard to know, of course, based on oral argument, how much of it is sort of, theatrics, how much of it is actual. I want to know the answer to this question, and how much of it is, horizontally face punching other justices on particular points. But I mean, to me, it was surprising. Only Barrett seemed to come back over and over. Wait a minute, I really want to know about this distinction between when the states do these things and when private actors do these things, and how we figure that out in terms of what that means for commandeering. And it was sort of like Bueller, anyone, right? And you would think, given that the state of Texas had equal time with the Brackeens, that this issue would have been more prominently discussed. Again, the 227-page transcript, it does not come up all that often for some reason, which we will not know until we know how the story ends. We don't know why they were so fixated on Article 1. We don't know why they seem to be so fixated on equal protection. I thought there was a non-delegation issue floating around here somewhere too, which never reared its head. No one cared about that, right? Gorsuch mentioned standing once. There was maybe a softball question on standing, but Article 1 seemed to be the thing that they were fixated on the most, plus equal protection as conflated, as I mentioned before. So what does that mean? they've all made their minds up, or we don't care. We want to do something about plenary power and or equal protection. And that's cute. You're here at Texas, but yeah, that's not something we're all that concerned with. Who knows? We'll know by June 2023.
Okay, so I'm looking at, we've got questions going on in the Q&A and also in the chat. And I apologize, I'm not disregarding anyone. I'm just doing the best I can to field the questions that I can see. Someone had asked about a reference to the Hague Convention during oral argument and asked if you can talk about that a little bit more.
So I'm happy to weigh in briefly on that. You know, I think that there were, I think this was Gorsuch as well, and there were a number of comparisons to sort of other types of other areas of law where Congress has plenary authorities, and sort of what it would mean to decide in this instance that Congress, you know, to Paul's point, right, that like suddenly the word plenary doesn't mean plenary anymore, and what that would mean for all sorts of other areas, especially some of the parallels that were used in other areas of law, including the Hague Convention, were other things related to children. And so there's, I think it's, I can't remember which brief, Erin, you might remember, but there's a brief, I think, of constitutional law scholars that cites a whole bunch of different statutory authorities that would all essentially be thrown, statutory and treaties and conventions, as in this instance, that would all be sort of like thrown into chaos. And Gorsuch did mention that in this context of saying sort of like what you're putting before us, both in Indian law and then also much larger, is that we would be an incredibly busy court if we ruled in favor of some of the breadth of what Texas and the Brackeens were arguing for. The only thing I think is interesting on that too is that the argument from Texas about sort of what the limited scope of plenary powers should be was a bit vague. There was sort of like a 3-point test, but it hadn't been sort of fully formulated. I wouldn't say that the US government did an amazing job either of sort of advocating for how broad plenary powers are supposed to be. So I do think that that's an area that, to Paul's point of, you know, it's very difficult to read the tea leaves, but it is concerning that we don't know sort of exactly what the wording would be to come out on sort of the court's interpretation of plenary powers in this instance, and what that might mean for things like Hague Convention and other.
And, you know, and just one point on that too, I think, you know, one of the other laws that folks have mentioned a lot in one of the briefs, and I think you're right, Prudence, and now I'm struggling. I think there's also the historian's brief, I think also kind of goes into some of this as well, but and I'm going to mess up the name of the law, but it's the Civil Service Members Relief Act, something like that, right? Which is basically a law where Congress has told states, hey, when folks are deployed, you can't foreclose on them, you can't repossess their car, you can't terminate their parental rights, right? It's meant to protect troops who are protecting the country, and it explicitly is an example of the Congress explicitly telling a state that it cannot do something in an area of child welfare. And so, you know, again, that was, I think, brought up in at least a couple of the briefs and at oral argument. And this ties to the question about the Hague Convention of like, actually Congress has done this, and you know, ICWA is not unique. That's one of the things that the opposition has really sort of been trying to hit over and over, is that ICWA is this very unique law where Congress did this thing it wasn't allowed to do, and it's like, actually no, this is fairly routine, you know, for Congress to do this sort of thing, and so really helping the justices contextualize ICWA in the larger sphere of child welfare, but also Congress's power over, exclusive power over a number of different issues. And I was just looking at the chat, but I'm sorry, Suzanne, I don't want to jump in.
No, go ahead.
So there was a question about the, you know, it seems like the justices spent a lot of time on the placement preference, that third placement preference And I think that's a really good observation, right? It seemed like the third placement preference and then active efforts, the justices were really trying to understand how those provisions of ICWA work, and again, this kind of goes back to one of the earlier comments about child welfare cases are really in tribal courts and in state courts. And so it's there, the federal courts don't often get questions about how child welfare systems are actually, like the mechanics of it, how they're functioning. And so there was some real, I don't want to say confusion, but just a lot of questions about that, right? And I think it is, again, we wouldn't want to speculate, but yes, I think you could, to answer the question, you could see an opinion where maybe the justices strike down that third placement preference, but keep the rest of the law. I don't know that there's any good data out there about how often that placement preference comes into play. I would have, maybe if we were tracking more data points in AFGARs or something like that, we might have more data on that. I think in some states it's very rare. In some states it might be quite common, right? Especially if you are in a state like Alaska, where, as I mentioned earlier, there are 229 tribes. There are a lot of small tribes that are neighbors to each other, that have common language, common culture. And that third placement preference, does come up quite a bit in those contexts. And it would be entirely appropriate, right, for a tribe to, or for a child to be placed perhaps with a neighboring tribe. So I don't know, we'll see. I mean, I think one of the smartest things that I thought Ian Gershengorn, who argued for the tribes, was excellent. And I think one of the very smart things he did was one of Justice Barrett's questions at the end was to say, I don't know. She had a question about sort of the mechanics of ICWA and how it was working. And I think just as a lesson for lawyers, right, it's a good lesson to, it's a good skill to just admit when you don't know, right? Because I think there's a lot of danger in sort of fake it till you make it lawyering, or saying the wrong thing, especially when the stakes are so high and you're at the United States Supreme Court. But I also think that that answer is great because I think it pushes the justices to go back and to read the briefs, right, which talk in detail about how things work and were written by experts in child welfare. And then it also highlights the issue that came up at the end of oral argument about whether or not this case is even a good vehicle for determining any of these questions or the constitutionality of ICWA. This is a facial challenge. We don't have specific facts and specific cases before us. And what the ICWA's opponents are asking the court to do is so broad and would have so many impacts, not just on child welfare, but on federal Indian law as well. This case is a terrible vehicle for, evaluating all these questions. And so to me, Ian saying, I don't know to that question highlighted that, and I thought it was very smart of him to do. So, Paul, you came off mute. I'll kick it to you.
Oh, your time is almost up, but I want to say it would be very unfortunate that the third preference would be the tail that wags the dog in this case. Not one of the families was actually affected by that provision. And therefore, it's a red herring. It's inserted specifically to attempt to destroy part of ICWA that none of them were actually affected by. But also, it depends on how they deal with the third preference. One of the things I wanted to throw in there in terms of the oral argument, when reading the transcript again, became more apparent to me. They don't know what a racial statute is and what a political statute is when it comes to Indians. And the unfortunate urge, it seems, by some of them is to look at the purpose of the statute, not the definition, to then decide, well, I don't like it, therefore it must be racial, versus it may be political, it might not be rationally tied, which even the most hostile majority of Fifth Circuit en banc judges actually did. They never said it was racial. They said it was political, but the third preference was not rationally tied. Now, is that the best of the worst of the various metaverse scenarios? Perhaps, but never let us forget, they don't have standing, period, to bring this up, and therefore it should not make a difference at all.
Well, we are at the top of the hour. Like I said, we could really talk about this case for hours, many more hours. But unfortunately, we can't do that today. So we would like to thank all of the attendees for joining us today. And we would really thank you so much to the panelists. I have been following this case and I learned so much sitting here listening to you. I've been over here madly scribbling notes. So thank you so much for your time. Your work is so critical for so many reasons. And so from the ABA, they would like me to say that the section of Civil Rights and Social Justice provides these free webinars as resources, and we hope they've been helpful to you. And please consider joining, as the president said earlier, and becoming active in the ABA. And we wish you the best of luck in your work and the best to you.